Hello viewers, welcome to Ekam Academy. Today we are going to discuss about POCSO Act. So what is this POCSO Act? So Prevention of Children from Sexual Harassment Act. Okay, so this POCSO Act was enacted in the year 2012. So why it was enacted? Mainly to protect the child from sexual offenses or sexual harassment related things. Okay, so children has to be protected. So we'll know the features of this particular act, and why we are going to discuss about this particular topic today is, you might already have come across that one former chief minister of one particular state, he was accused of like child sexual assault related things, and he was booked under the POCSO Act. Okay, in this context, you need to know what are the provisions of this POCSO Act. And in the recent times, only like 6 months back or something, Supreme Court has underlined the criminalization of this consensual act, sexual acts under this POCSO Act, and also at that point of time, it asked the government to lower the age of consent. What is the meaning of age of consent? So, what is this particular law? Why it is called as gender neutral law? And also, what are the provisions of this act? And who are punishable and who are not punishable under this act? What are the changes that needs to be made to make it more rigid? And all these things we are going to look as part of this video. So, without any further delay, let's see the what are the points of discussion. The name of the act we are going to discuss is POCSO Act. Why it is in use? You have Protection of Children from Sexual Harassment Act. What are the features of this act? What is the issue of minors being booked? Okay, for consensual act, we'll understand this in detail. And what is the recommendations of 22nd Law Commission with respect to this POCSO Act, and why is it against the lowering of age of consent? So we'll understand what is the meaning of age of consent, and then we'll understand why the Law Commission is against the lowering age of consent, and also we'll understand what is the role of Law Commission, and we'll understand what is the way forward in this particular issue. So without any further delay, let's see the syllabus mapping. It forms under GS1 under society, or even in social issues aspect, you can say. Then it why we are discussing is, former Karnataka Chief Minister is booked under POCSO Act for child assault. Like there are allegations that a 17-year girl was accused sexually, or like was also you can say was assaulted sexually by this particular person. So under this grounds, he was booked under POCSO Act. Okay, so we'll understand what is this act in detail. So first thing you need to know is, what is the meaning of the word POCSO? POCSO means Protection of Children from Sexual Offences Act. Okay, so children are more vulnerable, no? So in society and social justice also, we have many provisions for children. So protection of children from sexual offenses. So they are vulnerable and they can be easily targeted. So in these cases, we need to have more punishments, or it has to be more punitive. So that is why in 2012 this act was brought. So main thing you need to know is, this is the first comprehensive law that is dealing specifically with abuse of children in sexual domain, in which was enacted in 2012. Before that, we have different acts, like you have Sexual Harassment at Workplace Act in case of women in 2013. After Vishaka guidelines, we have that was brought by Supreme Court subsequently. On the orders of Supreme Court, it was brought. And there are different types of acts, but this act is dealing with child sexual offences. This is a first in India. So do remember this. And this is under the domain of Ministry of Women and Child Development. Very importantly, you need to know the ministry also concerned. Then if you see, it was intended to protect the children from sexual assault, not only sexual assault, then sexual harassment, and also pornographic violations. That means in case if they have resorted on any pornographic violations also, that also will be under the ambit of POCSO Act. And special courts also will be established for these type of cases, so that fast tracking will be there, and you can have justice in a very less number of time. Because if you normally approach the normal court system and all, it may take long time, right? And there can be delay in justice, and that may turn in favor of the offenders also, the persons who have committed offense. So in that situation, we need some special fast track courts that were also established part of this act. In 2019, this act was amended to strengthen the penalties. As we know, after this Nirbhaya gang rape, criminal act amendment was passed in 2013, under which in case if a minor was gang raped also, we are awarding death penalty. So in these situations, the stringent penalties were also imposed after 2019 amendment. So we'll understand what are the more important provisions, key provisions you can say, under this act. So you have, first thing is gender neutral legislation. So what is the meaning of this word gender neutral legislation? Means it doesn't differentiate between girl and boy. So normally, whatever the other acts we have, like sexual harassment of women at workplace, the name of the law itself is suggesting women there. Or like whatever the acts we have, there will be gender specific legislations only. But for the first time, we have a gender neutral legislation. That means there won't be any differentiation. Even if a girl is subjected to sexual offense, same kind of punishment, or even if a boy is committed is undergone sexual offense, so at the same time, same offenses will be awarded irrespective of the gender. That is why it is made as a gender neutral legislation. Only if it is a children, or only if the subject matter is children below 18 years, irrespective of girl or boy, this will be applicable. That is the meaning of gender neutral legislation. Then non-reporting is a crime. For example, if the children, children will normally be part of the schools or colleges at that point of time before the attaining age of 18. So in any academic education institutions or somewhere, okay, where they are subjected to the sexual violence, if those institutions doesn't report the sexual offense to the higher authorities or the law enforcement authorities, you can say, then this will be a crime. So law and non-reporting is a crime means any person who is in charge of that institution. So not children, because they don't know, below the age of 18 means they may not be aware of the law and they don't know to whom to approach and all, right? So they need to the institution where it happened. For example, in the recent past, we have seen bus drivers conducting sexual offenses against the children. In Hyderabad also we have seen these type of offenses, no? So when these things happen, so the institution which is responsible for these things, okay, they have to report this crime. In case if they don't report, thinking that it will become a legal challenge or it will become a difficult situation for them, then it becomes a crime. So this is the main provision. Then no time limit for reporting the abuse. No time limit for reporting the abuse means here the victim normally will undergo a shock type of thing, no, immediately after the sexual harassment or whatever the sexual assault is there. So they may not easily respond immediately, and even they cannot even report to the parents. Sometimes even they don't know what happened to them also. So under that shock or something, they may not report immediately. So there won't be any time limit. That means within 24 hours or within 48 hours only you have to report. There are no such restrictions. Even after many years also, if they come across that, okay, this is what sexual harassment happened at that point of time, then they can report to the concerned authorities. There won't be any time limit. Then keeping the victim's identity confidential is the highlight, you can see. So that is very important to protect the victim's identity, otherwise media and all these people can start publishing the names and it can become sensational issue. So it disrespects and the right to privacy, and is also part of this fundamental right, and even it is applicable to the children also as part of article 21, right to life. So keeping victims identity is also confidential under this act. Then what are the concerns? We'll understand. Concerns is such abuse is on the rise because of the COVID-19 and all, people are at homes only, but what happened is there is increase in more number of cyber crimes. So online only people, so they didn't even send their childs out to play because of the fear of COVID-19. But at the same time, what happened? They got addicted to more number of cell phones and they started engaging with friends online, and all this have led to increase in the cyber crimes. So this is a increase, is the main concern. Then lack of awareness or knowledge. So the minor girls, boys, or parents, and even the society also doesn't have much awareness about the particular act and its provisions. Then criminalization of adolescent sex. Here you need to know what is the most important thing is adolescent. Adolescent means between the age group of 16 to 18 years. So in case what happens in this, so we have seen according to the POCSO Act, children means anyone below the age of 18 years. Okay. So, but here what happens is if the boy or girl, okay, they're in the age group of 16 to 18, and by consents, that means if they're willingly participating, consents, if they're willingly participating in adolescent sex, that means between this age group, okay, so then it was criminalized under that. That means with their wish, if they participate also, that is criminal act, so they can be punished. So this is one main concern. So this has led to the Supreme Court. So Supreme Court said like this criminalization of adolescent sex related cases are on the rise. So you please look into this issue whether you can decriminalize this adolescent sex. So the Supreme Court of India has asked the government of India to look into this aspect. So then what did government of India do? It has recommended, or it has asked the Law Commission of India to recommend on this particular aspect. So then what did the Law Commission have recommended, we'll see. So the minors aged between 16 to 18 years who engage in consensual act of sex. Okay, so under the definition, it will come under sexual activity under the POCSO Act. So the minor boy and girl, okay, both can be booked in case if they resort to any consensual sexual act. That is the main provision which became controversial. So while these cases are not, in these cases, what happens is the minor boy, he may not be arrested or he may not be convicted. But what happens? There won't be bail will be not be given to that person, and he will be under detention only. So according to the Supreme Court data, one in every four cases of this POCSO Act, okay, so from the West Bengal, Assam, Maharashtra, they have constituted romantic cases. That means willingly the boy and girl are participating. So this is showing the trend that consensual relationships are increasing. So this, if consensual relations are increasing and if that is becoming a criminalized act, then it is definitely a raise of, you can say, a matter of concern, right? So then the law commission was consulted. So under Rituraj Avasti, this 22nd law commission has recommended certain things about POCSO Act. What did they recommend? In case if you are lowering the age of consent means above 18 years, any children, so they are free to choose whatever that is suitable for them. But if you want to reduce this 18 years to 16 years, and if you say even a 16-year girl also, if she can decide to with whom she can participate in sexual activity and all, that can be counterproductive for the woman itself, because women are most vulnerable. They can saying something, or they can make them easily fall into the trap, and they may sell woman trafficking, or sexual rackets will be there. All these kind of things are prevalent, no? So this lowering the age of consent from 18 to 16 may become counterproductive for women. That is what the law commission has recommended. And commission also said awareness measures need to be increased, and also sexual education also has to be made mandatory in all the schools, especially with respect to the POCSO Act. This is what they have recommended. Then why the commission is against the lowering of age means, you need to understand two key issues here. Why? Because in the recent times only, if you have remembered, in 2022, Government of India tried to increase the marriageable age for girls from 18 to 21. Previously, we have this 18 years. Now also this is a marriageable age. So this law was not passed, and it was not coming to effect, no? That is why they wanted to increase this to 18 to 21. So in case if you are increasing the age to 21 for marriage, then if you are reducing the age of consent from 18 to 16, then it will make definitely the woman vulnerable, no? So under this trap of love or something, okay, so they can trap the woman and they can make them sexually exploited. So that is why the law commission said no, we are not in favor of lowering the age of consent for the woman. So second thing is Muslim personal laws. So Muslim personal law, now what is a marriageable age means 18. But under Muslim personal law, what is the age of marriage means? It is puberty. Puberty means whenever she becomes mature, okay? So that means at the age of 15 generally. So that is considered as a marriageable age. So these things are not aligning with the POCSO Act. So this cannot be implemented. That is what the Law Commission has recommended. So age of consent under the POCSO Act it has to be minimum 18 years only until this will be increased. So that is what the Law Commission has recommended to the Government of India, as Supreme Court has tried to examine into this issue of criminalization of consensual sex under the POCSO Act. Okay. And then what is the role of Law Commission in India? Law Commission is neither a constitutional body nor a statutory body also. It was only an executive body. It was only executive. That means executive body means it was formed after executive resolution of the government. So, in 1833, we have Charter Act. After this Charter Act only, Lord Macaulay. So, he was the first chairman of the Law Commission in the British India. Subsequently, in 1955, after independence, our first law commission was formed, and it works for generally 3-year tenure. Okay, so subsequently we have till now 22nd law commission functioning. So 22 times law commissions were constituted. So these are temporary bodies, means after 3-year term that a law commission term will expire, then we have to subsequently constitute again the law commission. So whatever the law commission's functions are there, means it has to advise the government on law related aspects, policy related aspects, and it can make some recommendations. You will see different number of reports with respect to law commission and the recommendations given in that particular context. Even with respect to simultaneous election also we have seen. Supreme Court, like yesterday itself, we have seen, no, Ramnath Kovind-led panel has given in favor of simultaneous elections. So in that they have even included Law Commission's report. So in 1999 also it have supported the idea of simultaneous elections. Like that number of things are suggested by the Law Commission. And do remember, whatever the reports of Law Commission to the Government of India are there, those are only advisory and non-binding in nature. So these are non-binding. Okay. So three members will be part of this commission. You need to know who is the current chairman and all. Do remember those facts. Then what is a PM's question given for practice study? In relation to the simultaneous election, we have seen President of India from time to time may fix the number of election commissioners of the election commission on the basis of A, advice by the chief election commissioner, B, advice by the prime minister's office, C, recommendation of the union law minister, D, law made in the respect by the parliament. So answer is here in respect of the law. So in case if they wanted to increase, that is why we have seen no constitution originally had only one CEC. Subsequently, after this 1988 only, this one was increased to 2, 1 plus 2. Okay, 3-member body was made after the parliament has enacted a law in the same matter. Okay, then what is the time? Now we will see the time. Or it's the time for practice question given today. Who is a child under POCSO Act? Okay, what are the options given? You can see 18 years, 16 years, 14 years, and 10 years. According to the discussion, you can answer in the comment section. Then mains question given for practice is the rhetoric over severe punishments should not deflect our attention from the problems related to implementation of POCSO Act so far. Discuss in the context of POCSO Amendment Bill 2019. So this is a mains question given for practice. In this context, try to write down what are the problems that are faced in the implementation of POCSO Act and how severe punishments are not minimizing the number of cases registered under POCSO Act. As we have reached to the end of the video, today we have discussed about the provisions of POCSO Act. So prevention of children from protection of children from sexual harassment or sexual offences Act. We have seen why it is called as gender neutral law. We have seen that means it is not differentiating between a girl or boy. So anyone who is subjected to sexual assault, sexual harassment or pornography related challenges, they can be punished if they are below 18 years. And you have seen this act was enacted in 2012 under Ministry of Women and Child Development. And also do remember that there is no time frame to report the cases, and we have seen there is no reporting as a crime. That means the institution responsible has to be report. Okay, they has to report this particular crime. And also we have seen other interesting things also, like what is the Supreme Court, why did Supreme Court ask to decriminalize or asked to examine whether this criminalization of consensual acts can be reversed. And also what is the opinion of Law Commission in this regard. We have seen why Law Commission is against the lowering of age of consent. So what is this age of consent we have seen? So consensual act of sex. So we have seen different reasons, and also we have seen about Law Commission of India. So this is all with respect to today's discussion. Thanks for watching. Have a good day.